Hey everyone, Jarrett and I are jumping on very quickly because there was a hearing this morning. Today is August 21st, it's a Wednesday. There was a hearing this morning for the 5 suspects in the case of the tragic killing of Veronica Butler and Jilian Kelley. And as you all know, we've been breaking down a lot of these court docs, or Jarrett has, because a lot of them can be confusing for people like me and maybe people like you who don't understand what all of it means. So while we're waiting on the filings from today, which hopefully should be posted later or tomorrow, I wanted to grab Jarrett and just talk about the filings that came out, I believe, on the 15th of August and they were filed by Tiffany Adams, her team, and then Cora Twombly's team as well. And then I believe it was the 8th. It's just worth mentioning. Cole Twombly had filed something because he has a new attorney who is not a paid attorney per se, or a paid defense attorney. It's just a public defender. But Jarrett, can you just talk about the motions that first of all were filed by Tiffany and her team on the 15th?
So yes, first of all, just a public defender. They're a hell of a bunch of lawyers, just so you know. So they're very
sorry.
good.
Yeah, I wasn't. I just kind of meant like it's your taxpayer money, guys, that are paying. People
but
in the area.
In this particular case, it seems like Tiffany and Cora's lawyers are very, very active. Okay, they're jumping on every motion, every request of the state. So the state has done 2 things. Okay. They have notified all the defendants that they intend to perform certain consumptive testing, which basically says we're going to analyze a DNA sample. In doing that, it's going to eat up the entirety of the sample, okay? In order to do that, in a death case, in a criminal case, you need to get an order from the court. You need to notify the other side, and they're given the opportunity to respond. So what's happening here really is Tiffany Adams, through her attorneys, and Cora Twombly, through her attorneys, have said, hey, Mr. DA, you're going to use up all this DNA evidence? Not so fast. We want our own people, our own boots on the ground to determine that, number one, this testing is actually going to use up all the evidence. Or if it's determined that it is, we want our people there to observe the testing, ensure that all of the protocols and controls are complied with, because once this sample is gone, it's gone forever. So this is a big deal. I mean, the attorneys, if they don't do this, are committing malpractice. You can't just take a DA's word for it when your own client's life hangs in the balance. So the lawyers for the God's Misfits here are saying, not so fast. We want to be there. We want to ensure that if this sample is going to be destroyed, all of the rules and protocols are followed. They're doing a good job, and they have to do their job. So this stuff in the world of, I've done capital prosecutions. In the world of capital prosecution, you see this. It's pretty typical.
Okay, you used some big words here. So, can we go back? What exactly do you mean by, I guess, this before you destroy any samples? Exactly.
So what typically happens is you have a very small sample that is taken for DNA analysis.
And in this case, it is jewelry, right? They're talking specifically about
jewelry? No. That's a different motion. We'll talk about that in a second. The consumptive testing really relates to these serological, if that's a word, serology swabs that were taken of certain staining and certain DNAs. When the examination of those samples is done, there are agents or liquids applied to them. They're spun in a centrifuge. Oftentimes the sample itself is destroyed. So they're telling the defense, hey, when we do this testing, the sample we've collected is going to be destroyed. Are you okay with that? The defense is saying, no, we want our own people present, and we want you to show us how it has to be destroyed. Like there's nothing that'll be left. So fairly typical in these cases.
Okay, got it. Let's go to the jewelry. Let's go to the jewelry they're trying to test. And I'm like, I get it, right? You are allowed to test everything. The defense is allowed to test everything that the state is testing. Absolutely. But what could Tiffany's team be looking to test from this jewelry, Jarrett?
So, okay. that question jumps ahead of what's really going on with the jewelry. So the state has notified the defendants that there are items of jewelry that are to be returned to the victims' families. Oftentimes in cases, you recover items that on their face have nothing to do with the case itself, have not been utilized in the procurement of evidence. And they say, we'd like to return these particular pieces of property back to the family. They ask permission of the defense before they do that. You can't just be taking articles off the bodies and handing them back. The defense is not saying there's DNA on the jewelry or we'd like to test the jewelry. The defense is saying, hey, what's the rush? We haven't even had an opportunity to inspect all of the evidence yet. We don't know if this particular item is relevant. So before you turn it back to the families, we want all of our discovery. We want the opportunity to examine these things before you give them back. It's that simple. And
that's
quite honestly, that is the defense doing their jobs. They're doing a good job. You can't, I mean, you'd be committing malpractice if you're like, if they called and said, Jarrett, we have all these articles of evidence. You don't know where they fit. You don't know if they have any evidentiary significance. Do you mind if we take them out of the chain of custody and give them back?
Yeah, I mean, but you're saying that the state never asked. They just said, we're going to give these back. And the defense is like, no. Don't get used to this here, taking everything that you're finished with and not giving it to us. Because I think what I was interpreting that, obviously, as a lay, I was like, well, are they accusing, is the defense accusing the state of withholding evidence and withholding things from discovery here? Because and we can go into this with Cora's, it just seemed like they were being slightly accusatory if I'm reading between the lines, but
well, I think the tone, first of all, the state did ask. They put them on notice of the return of property. So their response, there's always like a bend to this stuff. There's always like, clearly it's an adversarial proceeding. They're defending their clients. They're saying, hey, you guys want to give this stuff back. You know damn well we haven't seen it yet. So that's the tone I would say. And it doesn't even mean they're hiding it from them. Oftentimes, so what would typically happen, and I've had cases with this kind of evidence, okay? Large evidence collected from a buried body. You would have an opportunity or several opportunities for a defense attorney to come in and physically examine that evidence, including the jewelry that was removed from the bodies. I've had bags filled with earrings that were removed from bodies that were in the ground for over a year. They have to be doing their job and look at those items personally and then determine if there's any evidentiary significance. They cannot take the state's word for it, or they should not. And that's not to say the state's lying.
Yeah, and you're right. You see these defense attorneys or these public defenders, and Tad is another story because he is using a paid defense attorney, and he seems to be wanting to do his own research, and he's requested law books from the library, all this stuff. But you're right, Tiffany's attorney and Cora's attorney, I feel like they are like, we need to get maybe the death penalty off the table. That's my thinking. But let's go to Cora. So her team is really coming down on this OSBI criminologist here saying, we need to be there and we want his resume and I'm like, that's crazy. Why do you think they're coming in so hard? Did something happen with this guy? I mean,
no. Okay. Before you, here's the thing. They're asking for the defense to rely on the opinion of this criminologist. Before you do that, you want to know who that person is. What is their relevant background? How are they an expert? Okay. Before I take somebody's word for it in an area of expertise, I want to familiarize myself with their background. So it seems like the motion, typically in a motion like that, where you're asking for the other side to take the word of a criminologist, you would attach that criminologist's CV or resume. So that adds credibility to your motion and it takes an argument away from the defense. They'd say, hey, look, we have this Harvard-trained criminologist who's working with us here, Joe Smith, and here's all of the cases he's been a part of. He's going to be the one saying these items are going to be consumed in this testing or whatever the contention of the criminologist is. The defense is saying, we want the opportunity to examine this person. We want the opportunity to look into their background, so we're not just basing our belief on their opinion on faith alone. And again,
Yeah.
Tiffany and the entire crew's lives are on the line here. This is not the place to just take people's words for it. They have to test the
Yeah.
evidence. They have to push back on the prosecution.
And they are clearly. I guess I'm just wondering, is this limited? I'm thinking of other cases and other trials. I mean, I guess I haven't seen motions like this before. Like, I'm thinking in my head, Karen Reed, for example. Why wouldn't the defense say, hey, I want the resume of, let's say, Trooper Paul, who was the accident reconstructionist? Why doesn't, I mean, and in my opinion, I'm obviously going down a rabbit hole, but this guy was totally not credible. He wasn't a good witness, and that helped the defense, obviously. But like, why does this seem
Well,
like it's
so you mean in Trooper
happening?
Paul's? So because the state may have given it voluntarily.
Okay.
The defense may have had it and they don't have to ask for it. So
Okay.
you
All
wouldn't
right.
ask for something you have. So typically,
Right.
when you give an expert report, that CV is attached to I have one right here. I mean, when you have an expert report, you attach the CV of, like, I have cases where people were injured and I have a physiatrist testifying. So
Right.
his resume is attached to his report. It builds, that's all part of build. And the first questions you ask that expert in court are, doctor, take us through your educational background, take us through your training, take us through your work experience. Why? Because you're just building this credibility tower for the jury to look at and be like, oh, wow, this is the greatest expert ever, that. So that's, but also the defense can use that as an opportunity to punch holes in a particular expert's. And I've seen CVs, the famous George Santos resume. Look at his resume. Okay, there were a couple holes in that resume.
That's a really good point. Yeah, no, that's a really good point. Okay, I guess I was just like, this is very specific. I mean, she's asking for a specific person's resume where it's like, okay. I mean, I guess I'm kind of like, so then what if they're not satisfied? They're gonna try to submit a motion to have their person be the sole I don't know. I mean, I guess we'll have to wait and see.
I think you have to look at this from a couple of vantages. Number one, you look at it from the defense standpoint. They're defending their client. You also have to look at it. They're protecting the life of their client, whether we like it or not. Their client's life is on the line. Number two, they are doing their job because it is a death penalty case. If the God's misfits get the death penalty, then a team of appellate lawyers are going to be examining every inch of this file, every filing of the prosecution and of the defense. And they're going to be looking for instances where the defense let the prosecution slide. That's what's going on here. It's defensive pool. It's protecting the record and protecting their clients and their lives at the same time. You are going to see a ton of this stuff leading up to trial in 2026. I know you don't like to hear that, but
I know I don't, because it just feels so far away, and I'm like, I can't handle all of this, and I'm like, I want to understand this immediately when things come out. But okay, so all right, that helps. Thank you for that. I am going to stay on top of the motions that were hopefully going to be filed today or tomorrow, and then we can hop back on and break those down and talk about what came of today's hearing.
You got it. Always happy to help.
Okay. All right. Thanks, Jarrett. And thank you, everyone. We, again, will keep everybody posted with this case.